Why would the defense attorney keep telling his doctor client to simply shut up during the course of my questioning him during his pretrial deposition? You want to know the answer? Come join me on this walk through the neighborhood as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Okay, so I had an opportunity to question a doctor in a medical malpractice case. Now, we have a chance to question him in a process known as a deposition. It's a question and answer session that's given under oath in his attorney's office. In this case, we were doing it online, virtually by Zoom. Okay, so now the doctor and his attorney were in the same conference room. I was on Zoom, and there's no judge there. There's no jury there, but there is a court stenographer there to record all of the questions that I ask and all of the answers that the doctor gives. You should know something. The answers that the doctor gives represents his sworn testimony, and it carries the same exact weight as if he is testifying at the time of trial, and as if there's a judge there or as if there's a jury there. Okay, so this is actually important. It gives me an opportunity to find out from the doctor exactly what he did and why. I get to ask the doctor what the standard of care was in certain circumstances. I get to ask the doctor questions about what his plan of treatment was. I also get to find out what he's thinking, what's his rationale for doing certain things. I can ask the doctor to explain about why he did certain things. I can ask the doctor short, leading questions that call only for yes or no answer. So, what happened in this case? In this case, I'm asking the doctor many questions that call only for yes or no answers. All right. So why is it that the defense attorney, the attorney who represents the doctor whom I was questioning, the doctor whom my client sued, why would the defense lawyer turn to his own client in the middle of questioning and say, "Doctor, shut up, stop talking. He didn't ask you that"? I'll tell you why. Because many times when I asked simple questions that called only for yes or no answer, the doctor felt compelled to give me explanations. The doctor felt it was important to go ahead and explain and give me context. The doctor wanted to explain the anatomy to me. And every time the doctor tried to explain, his attorney would turn to him and say, "Doctor, shut up! Stop talking! He didn't ask you that question." He had to remind the doctor repeatedly to answer only my questions. Now, think about this. I'm there to ask the doctor questions about what he did and why. I want to know very specific answers to my questions. If the doctor feels compelled to go ahead and explain, there are some instances, where I will go ahead and let the doctor explain as much as he wants. Now, why is that? And why is that different than if we were at trial? When I call a doctor at trial, I now have the ability to question him as an adverse witness, which means, and the whole key and the whole distinction that I'm trying to make is, I get to ask him leading questions. And a leading question simply allows me the opportunity to ask a doctor questions that call only for yes or no answer. "Doctor, on this date, did you do this?" "Yes." "On this date, did you do that?" "Yes." I don't want the doctor to explain anything on cross-examination. I want the jury to understand the entire story from the questions I am asking, and I simply want the doctor to agree or disagree. But in a deposition, a pre-trial deposition, it's totally different. This is the discovery process. This is an opportunity for me to learn more information and more details about what the doctor did. It's an opportunity for his attorney to learn more information. So that is why I will often ask the doctor to explain. However, many of the questions that I was asking this doctor during this deposition called only for yes or no questions. Yet the doctor still felt the need to go ahead and explain. Now, is that a bad thing? The answer is yes, it could be a bad thing for the doctor and his attorney, for the simple reason that the more the doctor talks and explains, the more likely it is that I'm going to find golden nuggets of information to use against him later on during the course of this case. The doctor will invariably give away useful information, either about the standard of care, either about his rationale that I had not yet asked him about, or about certain information that I had not yet addressed, that I might have addressed, but here he's going to voluntarily give me information. So even though his attorney kept telling the doctor, "Stop talking," I often will not interrupt the doctor if he wants to go ahead and explain during the course of this question and answer session that takes place in his office. The more information I can gather from the doctor about his reasoning, the more information I can cull and use at the time of trial. In reality, this question and answer session is designed for one purpose only, to answer my questions. And now the doctor is there for X number of hours for the day to go ahead and answer just my questions. He's not there to really volunteer and give detailed information. He's not there to go ahead and give a medical lecture about the topic. Instead, his entire goal is to answer my questions. And if I don't ask the right questions, then now I've deprived myself and my client the opportunity to learn more information from the doctor. So the defense lawyer, he happens to be a very good attorney, he's a good trial attorney. He kept turning to his client and saying, "Doctor, shut up. He's not asking you about that information. So why are you giving that to him?" And the doctor would respond to him and say something like, "Oh, but I wanted to give him context. I wanted him to understand why I did certain things. I wanted him to understand why on my curriculum vitae, my CV, it doesn't explain the following things." So why do I share this quick information with you? I share it with you to give you a sense of what really happens in these medical malpractice cases here in New York. You know, I recognize you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York and you have not yet started a lawsuit and are thinking of doing so, but still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day and I'd love to chat. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a wonderful day.